Welcome back to the Protecting Homeowners Podcast. I'm Marc, Dann.
This is our third episode. And today we want to talk about myths regarding foreclosure and see if we can put some of those myths to rest for you today. Say myths 3 times. That's hard for me. Who wants to start? Who wants to share a myth and so we can talk about what the reality is?
Well, I'll jump in here. The one thing that drives me crazy is hearing prospective clients demand and expect that they are going to get a free house just because the lender did something perceived to be wrong somehow. And that just rarely happens, if ever. The reality is, unless the error goes to a significant part of the case, that's just not going to happen. And even if it does go to a significant part of the case, that doesn't mean the lender can't fix it and still proceed with their foreclosure case. Whitney, have you run into this?
Yes, often. I think there's obviously the misconception that there's going to be a case that's worth a lot of money against a mortgage servicer, or there's going to be a free home at some point. And I have done this for almost 10 years, and I don't believe I personally have not seen a client receive or have a lien released on a house thus far.
So actually, this firm collectively has had that done about 5 or 6 times. We've had that outcome of a case, but the outcome is really incidental to the facts of the case and the civil procedure that goes on. In a foreclosure case itself, while you could get we frequently do. End up with judgments for the defendant in a foreclosure case. That's just the beginning of a process. That's not the end. In a court, so you could end up very easily with an unliquidated lien on a piece of property. So that if you wanted to sell it, if you wanted to refinance it, that lien's there, even though it may not be enforceable by way of foreclosure. So we've run into that situation. We've had, there is a remedy called quiet title, but the odds are strongly stacked against the homeowner in that situation. So there's that. In the affirmative litigation that we do, so when we sue your mortgage servicer, all the jury's allowed to give you is money. In fact, there is a prohibition under the Real Estate Settlement Procedures Act against injunctive relief. It's only money relief that's available. Now, in a perfect world, one could get enough money to pay off their loan. And in fact, the times we've had lien releases take place, it's been because we had strong RESPA claims against the servicer and claims under Ohio's Residential Mortgage Loan Act. I think there was a fear that the jury verdict would have exceeded the amount of the loan. And the other kind of quirky thing is that, since the servicers are basically collection agents, well, not basically, they actually are collection agents for the actual owners of the loan, the investors in the loan, they tend to prefer to settle cases with other people's money, not their own. And so by reducing a principal balance or a release or modifying a loan, that's a way for them to buy out their liability with somebody else's money. We look very carefully at those offers, by the way, and that's part of where Karen comes in to help us evaluate whether that offer that they're making to modify a loan, for example, as it's part of a settlement of a case, isn't something that the borrower could obtain without the leverage of the existing lawsuit. So it is a really important thing to understand that it may happen, but anybody that wants to come into a case with the expectation that they're going to not have to pay any more on their mortgage, frankly, we don't want to represent, because those unrealistic expectations will result in disappointment at the end of the case, even if we do an absolutely great job for that client. And so, but that's our job too, is to help people understand and to properly set those expectations at the beginning of representation. One thing to keep in mind, and we talked about this in our prior podcast, is that if somebody's promising you that you're going to get a free house through litigation, you should look very carefully at that offer and that lawyer that's making that representation to you, and maybe get a second opinion, because it would be such an unusual and rare circumstance where that would happen. Not that it doesn't from time to time, but it's often very, 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 very rare. Andy, we have a case right now that we're litigating where our colleague Emily White got a defense verdict at trial, and what's happened since?
Well, I was going to pipe in and talk about that case, and Emily did a great job taking a case to trial. And the court determined that the bank failed to prove its damages and granted judgment in favor of our clients, the homeowners. So that was 3 or 4 years ago that happened. And recently, the very same bank filed a brand new foreclosure case. And their position is that, look, just because we took it to a trial and lost doesn't mean that we still don't get everything we think we're entitled to. So we're now stuck fighting the battle again. Although obviously it's a lot easier this time, but it's still going to be a knockdown, drag out fight that could go on for years, because I see easily a potential appeal in this, and additional litigation. So even if we're fortunate enough to take a case to trial and win, that does not guarantee that it's over with. And when someone enters into litigation like this, they need to be prepared for the long haul battle, because banks and servicers, they don't care. You're just one more loan in their portfolio, and they're going to do what they normally do, which is try to bulldoze you. And unfortunately, when you walk into court as a foreclosure defendant who's in default, frankly, courts don't look upon you very favorably. So it's an uphill battle no matter how you look at it. It's one that can be won for sure, but don't think it's going to be easy. Don't think that you're going to get a free house just because the bank did something wrong.
And there's lots of benefits that can come from being represented in a foreclosure defense setting that are different from getting a free house, including getting your loan modified as a result of litigation and good representation. It could be extending the time that you have to stay in your house. Sometimes we talk about being in the due process of law business here. We provide you, and in judicial foreclosure states like Ohio and New Jersey, where we primarily practice, you're entitled to all kinds of due process of law, and that could take months and years, giving you the opportunity to get through a temporary financial problem. I mean, I often say, God forbid you get sick in America, because it could cost you your house. Well, we can keep you in your house while you're getting better. We've represented a number of people that were applying for Social Security disability benefits, and we were able to keep the ball in the air until those benefits came through. They came through with a significant back pay that we were then able to work with the client to use to redeem their house, and keep them living in their house. So that there's lots of outcomes that aren't getting a free house that can be extremely beneficial for you if you retain good foreclosure defense counsel. Andy?
Mark, yeah, just one other thing, and what Mark just described, I think is so important. You can't take a look at a foreclosure case as a snapshot. What's going on with the loan, what's going on with you in your personal life, what's going on in the litigation, everything, it's a dynamic process. And you have to take into account all of the moving pieces. And it's not just as easy as pointing to one piece of paper that says, look, they didn't check this box on this document. That's not the way it works. It's a far more dynamic, complex process. And I'd like to think that we're attuned to those various moving cogs to try to get the best outcome for the client.
Yeah, I liken it to a doctor treating the whole patient. You go to a cardiologist and he's going to only look at your heart, or she's going to only look at your heart. And you may have knee problems that have a relevance to some of the problems that you're having with your heart. Who knows? And we look at all those things very holistically. We look at other remedies that are beyond just litigating cases. We're not a one-trick pony, and so if we have to put you in a bankruptcy, we can do that, or refer you to a lawyer that can. So there's lots of different things. I want to raise another myth, because people have been contacting us, it seems like, later and later in the process, closer to sale, and as we talked about in a prior podcast, it's always better to reach out to counsel sooner rather than later, as soon as you have any indication that you're falling behind on your mortgage, because there's some planning and strategy that can be, or as former President Bush used to say, strategery, that can be used to plan that process and put yourself in the best possible position. But many people come to me saying, "Hey, I called you, but what I understand is that once a foreclosure begins, there's just nothing I can do about it. That I'm out of luck. I'm going to lose my house." Andy and Whitney, do you have any? Well, everybody's shaking their head. Who wants to go first?
I'll jump in. Well, first and foremost, you have to respond. You have to act. You can't sit back and hope for the best. And that includes communicating with your lender. That includes retaining counsel. As we've already discussed today, I mean, yeah, there are a lot of things that we can do to help people. And sometimes, even if we take a case to trial, we can beat back the claims of the bank. Though, just because a foreclosure is filed does not mean that all is lost. Mark, I've even had lawyers tell me that. Lawyers who allegedly practice in this area. I was dumbfounded. That's completely untrue.
Right. And proof is, we've opened over 10,000 files since 2008 at this firm. And probably 8,000 or more of those have been foreclosure defense files. And all of everybody has come in after a foreclosure, or almost everybody has come into us after a foreclosure has been filed. And many of them are still living in their homes. In fact, it's always great when I run into somebody at the grocery store or at the Browns game that came to us thinking that they were going to be homeless at some point, and who are happy to report to me that they're happily, that they're through whatever problems they were going through at the time, and that they're happily living in their house. So that's a great part of this practice. People, lawyers aren't terribly lovable in this world, but to have people be kind and appreciate you, and that's one of the best parts of this practice. Is our clients are awesome. Our clients are kind. They're people that are that really just want to be regular mortgage paying citizens again. And if we can help them do that, they have proven to be incredibly, as you can tell from, if you looked at my belly, they feed us. We represented a family that was a Spanish speaking family, and it was a long drawn out battle. I don't know if you remember this, Whitney, and they brought in the most elaborate Central American lunch for the entire crew here. We've had clients bake us cakes. We've had clients bring us donuts. In fact, if you want us to work a little harder on your case, just there's a word to the wise to get us going. But we're really lucky to be in this kind of a world. Whitney, how about you? Have you thought of any myths that you might want to share that?
Sure. I think one really popular myth is that, and Andy just touched upon this, is that the bank wants my house. Like there's a personal vendetta, by the bank, and Andy's 100% correct. You are just a number. You're a number in a portfolio, but I can understand why people think that the bank wants your house. A great reason for hiring an attorney is to deal with the mortgage servicer. And I can't tell you how many clients I've had over the past several years that have said, we've been trying to modify, we're talking to the mortgage servicer, I've sent these documents 10 times to Celine, or I've sent these documents 10 times over to, SLS, whatever. It seems like it's a nonstop process where people feel like they're just being taken advantage of and nobody's paying attention to them. And I think Karen could probably weigh in on this as well. But the truth is, we send documents over and over and over again and don't always have the response that we assume is going to happen or that should be happening. And again, that's the wonderful thing about us, is that we're paying attention to everything that is happening. And we're monitoring the dates and the times and the application process. And if they're not going to play ball, then we're going to document it and send notices of error and try to build a case against the mortgage servicer. But we like to take that, and we like to take those that time and put the ball back in your court. I mean, that's really what we're here for. But I would say that if you're in the situation where you are working with a mortgage servicer and you're trying to modify your loan, do not, and you're in a foreclosure and you are not being represented in the foreclosure, do not take what is being told to you on the phone as the gospel truth, because those mortgage servicers and the people that you're speaking to, those representatives, have probably little to no knowledge of what's going on in your actual foreclosure case. And let me tell you, the Supreme Court of Ohio came out and said, I want all resolution from the date of filing the case. They want these foreclosures wrapped up within 1 year, and you have a very limited window. And we want to keep that ball in the air long enough to get a modification, or do something, refinance your house or sell your property. We want to make sure that you're coming out on the right side of things, and whatever's best for you. And I can definitely see why somebody would think that when you're being told on the phone, hey, we're not going to move forward with the foreclosure, and then the next document you get in the mail is a default judgment, you're going to feel like there's a personal vendetta against you, and you have every right to feel that way. But truthfully, they're not after you. There's a process in place, and the right hand doesn't know what the left hand is doing. And that's why it's so important to hire an attorney to make sure your interests are protected during that period of time.
Right. We have a saying around here: never attribute to malevolence that which can be explained by incompetence when it comes to a mortgage servicer. And you see that, and they have as we talked about previously, they have very poorly trained staff on those phones, very poorly paid staff on those phones. We actually handled a wage and hour case against Freedom Mortgage, and we successfully got a settlement, a multi-million-dollar settlement for Freedom Mortgage. Hopefully they'll be kinder to us when we call them, I guess, for the folks that are on the phone, because they weren't paying them for the time that they were setting up their computers every day. They had 10 or 15 minutes getting all those programs up and running, and weren't getting paid for it. By the way, if that's happening to you, that's something else we can help you with. So keep that in mind. But we learned a lot by working with these folks directly. Wonderful people, well-intentioned, but not very well trained, and often not very competent, and certainly not anywhere near as thoughtful and capable as somebody like Karen Ortiz, who understands the Fannie, Freddie, FHA modification guidelines in a way that nobody on the other end of the phone is ever going to match. And I say that with some degree of pride. So, and one other thing to think about, I know Andy has something to share, is that actually, in most cases, a performing loan is the most valuable thing, the best outcome. So when a mortgage company has a client or a customer in default, they guarantee to lose that customer if there's a foreclosure. But if they can work them into a performing loan with a modification or a reinstatement or something else, then they actually will keep a customer and be able to bring more revenue into their servicing company. Andy, what do you want to share?
I just wanted to ask Karen, because I know how often I've been told, I'm going through the loss mitigation process. I'm trying to get a loan modification. And they said my foreclosure would be put on hold. Don't worry about it. Karen, you deal with our clients in the loss mitigation, the loan modification process. So you delve into that a lot more. How often do you hear that?
Oh, I hear it all the time. And it's like, no, it doesn't stop. And that's where it's kind of difficult for me, because I know all this information, but I can't really speak. You have to be careful when you're on the phone with the servicers, and you have to be careful when you're on the phone with clients, because it's such a tight and minuscule process that one wrong step and you may have just lost your protections under the laws. So what I can say as a non-lawyer is, the foreclosures are supposed to stop. Tell me when they don't, and I will notify one of these fine attorneys who will get the ball rolling.
Right. One of the rules that were established after the last financial crisis by the Consumer Finance Protection Bureau is that servicers are not permitted to dual track borrowers, and that's really important. That means that they can't, and this used to happen all the time. And all of us have been doing this long enough to remember having this happen. On one hand, the servicer is saying, oh, don't worry about that man behind the curtain, referring to the foreclosure proceeding that was going on in court. We're going to get you a modification. And then a day or so after they deny you a modification, suddenly a judgment's taken in the foreclosure case for people that didn't step up and defend the foreclosure at the same time. You have to assert yourself. You have to look out for yourself in this process. Whether even if you don't retain a lawyer, but by retaining a lawyer, you've got somebody now on the hook to do that work and to do it well. So, Karen, how about you? Any myths that you'd like to bust today? We have a little bit more time.
Sure, I have the most important myth ever. Just because the loan servicer said that you can put all the missed payments on the end of the loan and carry on with your loan like a normal mortgage paying citizen doesn't mean it's actually going to happen. Each investor has their own set of guidelines, rules, programs. Some of them matter what your income is, some of them don't. That's why it's so important to reach out and talk to someone who's knowledgeable in this, because you only get one shot.
That's great. Well, with that, believe it or not, we've used up our time. on the Protecting Homeowners podcast. We have been in trouble for running over on the first two, and so we're going to do our best to not get in trouble on this one. So we're under the 30 minutes that we promised to bring this in. But we've got a lot more to talk about. We have a list of probably another dozen myths that we can talk about. So we'll come back to that. And if you have questions that you'd like us to address on the Protecting Homeowners podcast, email us. Email us at Ava, AVA. Ava's our social media and coordinator among her many other duties here. Ava at DannLaw.com, and she'll make sure that we get those questions answered here on the Protecting Homeowners podcast. Anybody else have any last words to share? Well, until next week, thank you for joining us.